As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely green community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Thank you for joining us on the program today. The program is Voice, coming to you from Ben Television. My name is Tunde Alabi. This is a program where we take a look at legal issues here in the United Kingdom. What you need to know about all legal matters, ranging from immigration, business, investment, marriage, or everything that you need to know as far as living in the United Kingdom legally is concerned. Joining us on the show today, as usual, to review our community educational legal program is Jennifer Obaseki. Jennifer Obaseki is a senior partner at Obaseki Solicitors, and today we'll be looking at immigration compliance generally. There are rules that are expected of us to play by when it comes to immigration and compliance. Rules regarding removal compliance, signing compliance, overstaying or not overstaying. There are rules and orders we are expected to comply with as far as immigration matters are concerned in the United Kingdom. Some of these compliance orders where the Home Office expects us to be cooperative will be reviewed on the program today, and also we'll take a look at the recent Supreme Court judgment regarding appeal from abroad. It's going to be an interesting one. Just stay tuned on the program today. My guest on the studio, Jennifer Obaseki, is joining us on the show today. Jennifer, thank you for joining us on the program today.
My pleasure.
When we are dealing with immigration matters, the Home Office will expect us, in all sincerity, at all times, they will set before potential, people certain obligations and rules that they expect them to comply with. Say, yes, for instance, if someone is asked to be signing, you are expected to do that with all sincerity, and other compliance instructions and orders. Tell us quickly some of these compliance requirements and some of them that has gone to the court level.
To show that you have a full cooperation with the UKBA in their role as managing and enforcing immigration control in the United Kingdom, when you make an application, it doesn't automatically mean you're free without any conditions. First of all, you're granted temporary admission when you come into the country unlawfully or illegally, and then you present yourself to the authorities, because by right they can detain you. So if you're granted temporary admission, some of the conditions you may be given may be to reside at a particular address, maybe to report to an immigration officer at a particular reporting centre. It may be for a period, it may be for 1 day, and then thereafter there may be a frequency set as to the number of times you have to report within a month or within a 6-month period. The fact is, if you have children, you can ask for that reporting period to be reviewed, especially if you have more than one child, and especially if your children are of school attending age. So if, for example, you have 2 children and you're being asked to report once a week, that's quite strenuous on some people, even if it's every fortnight. So far as you have a pending application, you can make representations for the frequency of your reporting to be reduced. You may also be asked as a condition to present some information to an immigration officer to determine your case. And that information may be evidentiary, it may be further inquiries. So it's very important that you, one, give them an address that you're actually going to receive requests at, and number 2, that you provide the information in time. Sometimes they give a very short time to provide information, and you may need to write off make inquiries or receive information to comply with their request. So very, very important that if you cannot meet the deadline that you're given, that you ask for an extension of time to provide those documents. Sometimes they ask for documents from people that are ill. Sometimes if we've written to, for example, clients and they've not got back to us and they're maybe on admission, as good representatives, again, if you have good representatives, they will ask for more time automatically and not just not comply with the deadline, which may lead to your application being refused. But if we talk about some of the more serious compliances, such as failure to go and take your fingerprints or go and comply with the fingerprint request, sometimes people may have presented different IDs or made previous applications, so not realizing that they will have to make further fingerprints in line with their applications, do not comply with it. Again, it can be seen as a non-compliance, but it can also be seen as a non-cooperation, which has criminal sanction. Equally, not providing a document, again, where people may have used more than one ID or claimed more than one identity by making different passports or making previous applications. They may be hesitant to comply with this condition or request. And you again, when the Home Office makes these requests, you have to be very clear as to deadline and also as to reasoning. Sometimes these things are needed in order to determine your application. And believe me, when there's a non-compliance, it can lead to criminal sanction. And the criminal sanction can be up to 2 years. So we're talking about when it comes down to attending for maybe travel document interview or nationality confirmation with members of your embassy. If you're in detention, whether immigration detention or prison, and you fail to provide information, that is even to immigration officers or to members of an embassy, in order for immigration to help make an application for your travel document or for a passport, it can be seen as a criminal offence under Section 35 of the Asylum and Immigration Act. And it does lead to criminal charges. And you see, with regards to the attempts by the government currently to push forward with enforcement, many people in detention are being threatened with this action. So it's important that those who are in detention who cannot comply with the request, for example, if you have a further application, if you want clarification on the documents that immigration are presenting to you and you want advice on them, then it's important that you outline that you're not refusing to cooperate. You just need to have legal advice, or you need to have more time to consider the documents, but you cannot be seen not to cooperate. So it's very important that the people out there realize that.
When it comes to compliance removal process, say for instance,
or requests for information,
or requests, say somebody is being detained, basic signatories have been secured, i.e. signatory from the High Commission or the embassy of the potential person to be deported, and the person to be deported has refused to sign the deportation
or
paper,
even talk to the representative.
Will there be considered a kind of an action in breach of the person's compliance order?
Absolutely. It can be seen as non-compliance if there's no reasonable excuse. So the person might not comply because they have mental health problems. They might be severely depressed. They might be completely vulnerable and untrusting, having been in maybe lived in a regime where all officials were corrupt. There may be reason, but you cannot do it without explaining what that reason is. So if it's the case that, as I've said, you're depressed, you're vulnerable, suffering from mental ill health, you want legal advice, then you have to explain that, or it has to go down on record so that if you are charged under the criminal sanction and put before a magistrate, you outline why you're not guilty, or you outline why you should fall within the defence that is allowed under that particular charge.
Okay, but in where the case goes to court, say immigration officers the person
They
to
have to
court.
take you to the police to get charged first. And from what I hear, the police are not happy about this. They're busy enough than to have to deal with these issues. But it is there, and it's a tool that is going to be used now by immigration to use these criminal sanctions. So it's important that the community knows that the vulnerable people in detention may have a reasonable excuse, may have a defence to this if they are brought up on these particular charges.
If the person refuses to sign, will the person still be a subject of deportation?
If there's no reasonable excuse, not only will the immigration maybe seek to obtain a court order to carry out the process, i.e. getting the travel document needed, but it's going to be difficult because most foreign embassies don't like that type of thing. Why? Unless it's their subject, their citizen that is signing the document, they cannot be forced to create a document for somebody they have not clarified and confirmed is their citizen. That's number one. But number two, the person themselves, if there's no defence, no reasonable, proper, credible defence, you're leaving yourself open to criminal conviction. And that is serious because...
What do you mean by criminal conviction? Here is somebody who is already due for deportation.
Somebody who's already due for deportation.
You say criminal conviction.
But at the exit door, they're refusing to sign the paper or complete the process that will push them through the exit door. So while they're still inside the country, that charge of non-compliance will be laid upon them under the criminal section that is allowed, and that person may be convicted. And at worst, the maximum sentence can be up to 2 years. So rather than exit, that person may stay and go to jail for a longer term or for a short term. So as ironic as it may be, them refusing to sign and cooperate may keep them here in prison in the UK, yes. So
and then
it's
at the completion of the sentence,
yes.
And
they'll go through that same process again.
So
yes, you may extend your stay at Her Majesty's pleasure
indefinitely.
if you continue.
But Jennifer, the question is, without the person's signature, will the person still
be issued with a travel warrant?
Yeah,
it may come down to it, but as I've said, most embassies, most immigration teams in the very good embassies that we have out there will look to protect their vulnerable citizens. They will look to see that that person has exhausted all their rights of appeal, all their rights and entitlements in the UK, identify them as a citizen, which is the primary point. Because as much as the UKBA may say, you have no leave to remain, you have to leave the country, they cannot put you on any carriage, any plane, any vehicle, unless you have the documents that permit you to leave the country. And so either having a travel warrant or a passport is essential for them to transport you out. And they cannot issue that. Only the national government to where you're going to be removed to can do that, because no airline, no, as I say, transporter will carry you.
Okay, let's look at instances where deportees are maltreated or they are given some kind of unreasonable treatment in the process of deportation. We've had instances where
many and even fatalities.
Had them chained, some locked up in toilets, some very dehumanizing situation. What is the position of the law? First, for the deportee, two, for the carrier.
Well, the liability falls with the person responsible for moving them, number one. And number two, liability also falls with the person or agency, because sometimes it's not UKBA officials directly, it may be security companies that are engaged with the transport of the person. And at times, even on the aircraft, they are escorted by representatives from the security companies or UKBA employees directly. So it all does depend on who is actually carrying them. The use of excessive force is unlawful, it's unreasonable, and when it leads to injury, again, the person who carried out the action may be liable. It may be the officer individually, so it may be the person individually that can be sued, as well as the company or employers that they work for. In relation to the aircraft, or the carrier, as we would say, there's a number of different, considerations that have to be taken as to whether they are liable or not. If it's obvious that the person that they're carrying is unwell and harm comes to them, there could be liabilities because they have a duty of care to every passenger, even those who are being removed at the will of the British government. So again, the level of duty of care is there, and we have to also look at the fact that these types of situations are difficult to claim against. Number one, you need evidence. And often, when an individual is being deported, their mobile phones are taken from them. The only times that they usually are successful is when other passengers record what's happening. And some of the airlines actually isolate the person being removed if it's a public carrier and not a chartered craft. On the public carriers, sometimes they put the deportee on at the back first or on at the back last. So everybody is seated facing forward and doesn't necessarily look around to see any commotion at the back. So evidence is often lacking in some of these cases. Sometimes there's pictures of the injuries that we receive once the person's in their home country. Proving how they got those injuries then becomes the issue. So it's very, very important that if you are injured during a removal process, that you try to get as much documented evidence as possible. You try to get the names of those who are removing you, those, whether it's an agency, the individuals. If there is objective evidence not taken by you, maybe by staff or other passengers, you try to get them as independent witnesses. But you and I know these things are difficult, especially if you don't speak English as a first language. And often, as I've said, it can be difficult to bring claims, successful claims against
all right, let's move on because of our time.
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors, we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, SHARIAH law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
The Home Office over time came up with the idea of people being deported, thereafter appealed
from outside the UK.
Outside the UK. What is the update? What is the situation?
Well, yesterday there was a very good judgment.
What is the yesterday?
Yesterday
what is the yesterday?
Oh, yesterday, the 14th of
on the 14th of June.
Yes, the Supreme Court published a very important judgment which outlined where appeals from outside of the United Kingdom may be unlawful. To remove the individual and insist that they appeal from outside the United Kingdom is actually such a difficult process. And before the UK government actually initiated this appeals from outside the UK, many lawyers and human rights groups extended their deep concerns about one's inability to ever have a fair hearing once you're outside of the United Kingdom. How do you communicate? How do you discuss with your lawyer? How do you get your evidence? It goes on and on, and the cost. And the case is so important because it highlights all of these difficulties that individuals suffer when they are trying to have a fair hearing from outside of the United Kingdom. Can you reach your lawyer by phone? Can you type documents? Can you confirm documents? Can you confirm a hearing centre? Because these hearings are done by video link. Can you afford to pay for the video link? Can you afford to pay for the individuals to oversee the process? Can you get consent from your government to ensure that your evidence is allowed to be transferred in that manner? It goes on and on and on and on. And apart from that, the individual's rights, human rights, rights to fair hearing. Now, we think about Britain and the fact that we're en road to Brexit, but that in itself did not deter the Supreme Court judges from handing down this very needed decision, in my opinion, needed to make sure people have fair hearings. So, yes, Britain is going to formulate its own Bill of Rights within the next 2 years, we hope, smoothly. But in the meantime, people's rights to fair hearing, people's rights to actually put forward their evidence in a reasonable and proper manner cannot be thwarted, and this case actually stood up for those individuals.
What does the case, the judgment imply? What does the case, the judgment imply?
It implies that hearings where people are forced to carry out that process, and when I describe the process, which is leave the United Kingdom, exercise then your right of appeal, start to prepare your case, is unlawful, it is unfair, it is unjust. So there were a number of things that the judges looked at. The particular person that was subject to that particular case actually had children, had a partner here in the United Kingdom, and so the mere fact that many of those who were being forced to appeal from outside had criminal convictions because of the automatic deportation orders for those who had convictions of more than 12 months. It's meant that them just being labelled as criminals did not justify in itself ordering them or compelling them to appeal from outside of the UK. And I know that people who commit crime, yes, they're criminals, but many of them are rehabilitated. Many of them are family individuals as well, men and women. So to now put their children, their partners, such, let me say, such a burden and breakdown of relationships, the pressure that many people have been under as a result of having to appeal from abroad may be alleviated. So it's very, very important that if you are currently you're subject to an automatic deportation order, or you're subject to a removal, or have a request that you can exercise your right of appeal, but it must be done from outside of the United Kingdom. Please, please try to get urgent advice on this right now and see whether you can quote this case and the factors that were listed by the Supreme Court judges in this case to argue why your appeal should be considered within the United Kingdom. The mere fact that your appeal is going to be allowed in the United Kingdom is not, the end of the road. You still have to prepare it and prepare it solidly with your evidence, but it will stop that burden of having to leave the UK at a cost, and the real harsh headache of having to prepare evidence when you're not next to your lawyer or in amongst your family and the support that you need, among the resources that you need. It was very arduous for many people, and unfortunately many people did suffer having unfair hearings as a result of the previous regime. We hope it changes for the better. Everybody, no matter their history, should be entitled to a fair hearing.
Fantastic. All right, this is how far we can go on Voice today. We've taken a look at a couple of issues, taken a look at compliance, order, the implication, the role of the police, and of course, courts are now playing in this matter. And we also looked at appeal from outside, how the Supreme Court on 14th of June judgment here in London said it is illegal for somebody to be deported, well, reasonably where it is appropriate and considered to be deported, and said then appeal from outside the UK. You might want to explore this if you are affected. And this is a program today, Voice with a Pleasure, Start of Trouble. My name is Tunde Alabi. If you do need more information, get in touch with the phone number on the screen, or you get in touch with your solicitor or Citizens Advice Bureau. Better still, you can contact Jennifer Obaseki on the number on the screen. My name is Tunde Alabi. Enjoy the rest of your day. Bye. As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create a platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.